Hello, friends. So, we'll continue our discussion from yesterday. In yesterday's class, we had dealt with sections 1 to 15. And in this class, yesterday's one, we had a broad idea of what this Police Act is all about. It's a central legislation. Some of the categorizations within the Act, if you can do it, that we are dealt with in the yesterday's class. Today's class is very important. And in this today's class, we are going to understand certain topics that we covered yesterday. In the context of UP Amendment Act, what is the change that has been brought in the central legislation? भाई जो पुलिस एक्ट है वो सेंट्रल लेजिस्लेशन है, ये मैंने आपको कल भी बताया था. लेकिन अब एग्जाम जो आप दे रहे हो वो यूपी एपीओ का एग्जाम है. इन दिस यूपी एपीओ एग्जाम you have to definitely consider if any state amendment has been done by the Uttar Pradesh legislature, then you have to definitely keep that in mind. Because if they are going to ask any question, they're going to incorporate the UP state amendment in that question. So in this context, you have to understand कि जो कल की क्लास है उसमें हमने जैसे जब हायरार्की ऑफ पुलिस ऑफिसर की बात होती है, हायरार्की ऑफ पुलिस ऑफिसर्स विद इन द स्टेट, in that context you must remember that superior officers हैं, subordinate officers हैं. subordinate officers में आपकी जो पुलिस ऑफिसर्स की रैंक है वो शुरू होती है कांस्टेबल, हेड कांस्टेबल, देन आपका असिस्टेंट एसआई आता है, फिर एसआई आता है, फिर एसआई के ऊपर आपका जो है इंस्पेक्टर आता है. सो दीज आर बेसिकली द सबॉर्डिनेट ऑफिसर्स. उसके ऊपर आपका डिप्टी सुपरिटेंडेंट ऑफ पुलिस, देन सुपरिटेंडेंट ऑफ पुलिस या डिस्ट्रिक्ट सुपरिटेंडेंट ऑफ पुलिस, देन यू हैव the deputy inspector general, then inspector general. So the central legislation has contemplated until inspector general only. But since we understand that the Uttar Pradesh state is a big state, and in this state, due to the necessity, certain posts are also created which are above the inspector general. जैसे additional inspector general, एडिशनल डायरेक्टर जनरल ऑफ पुलिस और एडिशनल डायरेक्टर जनरल एडीजी जिसे बोलते हैं, ये इंस्पेक्टर जनरल के ऊपर आता है. एडिशनल डायरेक्टर जनरल एंड डायरेक्टर जनरल. नाउ व्हेन यू अंडरस्टैंड कि भाई जब ऐसी भी पोस्ट है जहां पे डायरेक्टर जनरल ऑफ पुलिस भी है हायरार्की में सबसे ऊपर, और जो आपका पुलिस एक्ट है वो हर जगह इंस्पेक्टर जनरल की बात कर रहा है, लेकिन यूपी में तो डायरेक्टर जनरल भी है. सो इन दिस कॉन्टेक्स्ट यू हैव टू अंडरस्टैंड इन ऑल दोज सेक्शंस इन विच जनरली द एक्ट इज कॉन्टेम्पलेटिंग द इंस्पेक्टर जनरल टू बी द एडमिनिस्ट्रेटिव हेड और द एडमिनिस्ट्रेशन इज वेस्टेड इन द इंस्पेक्टर जनरल. इन दैट केस इट हैज बीन अमेंडेड. अमेंडेड बाय विच एक्ट? अमेंडेड बाय द एक्ट ऑफ 1984. सो जहां जहां भी इंस्पेक्टर जनरल है वहां पे अमेंडमेंट से द इंस्पेक्टर जनरल हैज बीन रिप्लेस्ड. इन द यूपी स्पेसिफिकली इट इज देयर. इन यूपी ऑल बाय दिस अमेंडमेंट ऑफ 1984 इट हैज बीन रिप्लेस्ड बाय डायरेक्टर जनरल कम इंस्पेक्टर जनरल. क्योंकि डायरेक्टर जनरल तो आपको पता है ना, इंस्पेक्टर जनरल के ऊपर आता है. सो सेक्शन 4 हो गया, सेक्शन 5 हो गया. जब आप यूपी स्पेसिफिक पढ़ोगे, जैसे ये जो बेयर एक्ट आपको दिख रही है स्क्रीन में, ये आपको इंटरनेट पे भी मिल जाएगी. इवन मेनी यूट्यूब चैनल्स विच आर देयर, दे आर ऑल्सो डिस्प्लेइंग, दे आर ऑल्सो गिविंग देयर कोर्सेज ऑन यूपी एपीओ एंड दे हैव नॉट इनकॉर्पोरेटेड द यूपी स्टेट अमेंडमेंट्स. So this you have to keep in mind. And even when you will start reading the UP regulations, UP police regulations, then also you'll come to know that there is Director General of Police, then there is Additional Director General of Police, then after that there is the Inspector General Zone, Additional Inspector General, and so on. So this addition, it is there in your UP specific, which is there, and when you are targeting UP APO exam, you have to definitely keep that in mind. So section 4 में हमने जैसे देखा था, सुपरिटेंडेंस किसके पास है? स्टेट गवर्नमेंट के पास है, अंडर सेक्शन 3. Then the administration of the police throughout the general police district has been vested in which authority? Generally it is Inspector General, but in UP specific we have seen that this word Inspector General has been replaced by Director General cum Inspector General. And in such Inspector General of the police, and in such Inspector General, Deputy Inspector General, Assistant Inspector General as the state government shall deem fit. So यहाँ पे आपका जो स्टेट अमेंडमेंट है वो आपको ध्यान में रखना है. ओके, डोंट गेट कंफ्यूज्ड कि भाई इस एक्ट में तो आपका जो है इंस्पेक्टर जनरल लिखा है और जब क्वेश्चन आ रहा है उसमें बार बार डायरेक्टर जनरल लिया हुआ है. सो यहां आपको कंफ्यूज नहीं होना है. 1984 के जो स्टेट अमेंडमेंट्स हैं उसमें जहां जहां भी आप देखोगे ये यूपी स्पेसिफिक है, इसलिए सेक्शन 4 हो गया. सेक्शन 4 में आपका इंस्पेक्टर जनरल इज रिप्लेस बाय द टर्म डायरेक्टर जनरल कम इंस्पेक्टर जनरल. देन यू हैव अकॉर्डिंगली, सो जनरल एडमिनिस्ट्रेशन इन द स्टेट ऑफ यूपी is headed by whom? The Director General of the Police, and in such Inspector General, Deputy Inspector General, Assistant Inspector General, as the state government shall deem fit. Similarly, another section which was there, in which you have a provision relating to Inspector General. In all those cases, the 1984 amendment of the state of the UP has replaced the word Inspector General with Director General. So Inspector General of Police यहाँ पे change हो जाएगा. The Director General of Police shall have the full powers of the magistrate, shall have the full powers which is given under this act throughout the general police district, and shall exercise those powers subject to the limitation. So section 4 हो गया, section 5 हो गया, section 7 भी अगर आप देख लो, appointment dismissal. Section 7 is basically what? It's the disciplinary proceeding. So in section 7 also we'll see, here also the subject to the provisions of the state government may from time to time make under this act the Director General come Inspector General, the Inspector General, the Deputy Inspector General, Assistant Inspector General and District Superintendent may from time to time dismiss, suspend, reduce any police officer of the subordinate rank whom they think negligent, remiss, unfit for the duty. So यहाँ भी add हो गया है. Okay. सो सेक्शन 4 हो गया, सेक्शन 5 हो गया, सेक्शन 7 हो गया, एंड आपको सेक्शन 12 भी बताया था मैंने. लेकिन उसके पहले भी अगर आप देखोगे कुछ कुछ ऐसे सेक्शन है जहां इंस्पेक्टर जनरल है, हर जगह वहां पे डायरेक्टर जनरल भी ऐड हो जाएगा. ओके, डायरेक्टर जनरल कम इंस्पेक्टर जनरल, बिकॉज डायरेक्टर जनरल इज हायर इन रैंक एज कंपेयर टू द इंस्पेक्टर जनरल. ओके, इंस्पेक्टर जनरल के ऊपर क्योंकि स्टेट बड़ा है और भी पोस्ट है, और इसमें डायरेक्टर जनरल ऑफ पुलिस इनका सबका हेड होता है. डायरेक्टर जनरल जो है अदर डिपार्टमेंट का भी हो सकता है, होम गार्ड, अदर एंड सो एंड सो. आई विल जस्ट मेंशन व्हाट आर द अदर डिपार्टमेंट्स. लाइक यू हैव डायरेक्टर जनरल फॉर this home guard, fire service, training, and then additional director generals are also there of the respective headquarter, PHQ, vigilance, principal, training, intelligence, and so on. 21 around additional director general posts are there. Then you have IG zone. Districts had been incorporated into certain zones, and that zones are basically headed by the inspector general. So this special arrangement, it is there, especially in the case of Uttar Pradesh. And in the case of Uttar Pradesh, you have to definitely, since you are giving the exam of Uttar Pradesh, you have to definitely incorporate the amendments. So एक amendment ये हो गया, इंस्पेक्टर जनरल की जगह आपको डायरेक्टर जनरल ध्यान में रखना है, और 32A, 32B और 34A, ये चीज जो है ये भी स्टेट स्पेसिफिक अमेंडमेंट है उत्तर प्रदेश के लिए. So all these sections you have to keep in mind. And then in certificates also, certificate who will, every police officer other than the officer mentioned in section 4. Section 4 में मैंने आपको बता दिया डायरेक्टर जनरल है, इंस्पेक्टर जनरल है. ओके, डायरेक्टर जनरल, here you'll see इंस्पेक्टर जनरल, डायरेक्टर जनरल, deputy inspector general, assistant inspector general. Other than these officers, every police officer shall receive a certificate which is signed by whom? Which is sealed under the seal of which officer? Obviously the head of the general police district, that is the director general. So this amendment is also incorporated over here as well. Okay. So यहाँ कंफ्यूज मत होना, बस सिंपल ये है कि सिंस सेंट्रल जो लेजिस्लेशन है उसमें इंस्पेक्टर जनरल है, और यहाँ पे स्टेट में और भी पोस्ट हैं जो इंस्पेक्टर जनरल के ऊपर हैं, तो वहाँ पे रिप्लेस करके डायरेक्टर जनरल किया गया है. ओके. सो सर्टिफिकेट के केस में भी सर्टिफिकेट कौन देगा? हर पुलिस ऑफिसर को, अंडर द सील ऑफ द डायरेक्टर जनरल कम इंस्पेक्टर जनरल. Similarly, Section 9 remains unchanged because here the power to give the leave or the power to resign with 2 months notice is intimated to whom? The district superintendent of police. So here the situation remains unchanged. Then Section 10, I had explained you that the police officer cannot engage in any other employment. और यहाँ परमिशन किसकी चाहिए होती है? यहाँ भी आपको डायरेक्टर जनरल कम इंस्पेक्टर जनरल ही परमिशन देता है. If any police officer has to engage in some other employment, then the express permission has to be taken from the director general. Similarly, the power to make rules. Power to make rules यहाँ भी आपको with the approval of the state government, the director general come inspector general of police may from time to time with the approval of the state government frame such rules relating to the organization, classification, whether the particular services have to perform by whom, arms which are their recruitments, necessaries, intelligences and so on. So ये हो गया ऐसे स्टेट स्पेसिफिक अमेंडमेंट जो आपके जो है अफेक्ट करते हैं certain sections in the central legislation. These are Section 4, Section 5, Section 7, Section 8, Section 10, Section 12. We are studying Section 12. Apart from that, Section 13, 14, 15 and 45 also is there. रिटर्न जो भी फाइल करता है वहां भी था, तो रिटर्न वाले भी केस में डायरेक्टर जनरल हो जाएगा. ओके. सो डोंट बी मिसलीडेड. Understand what has been taught and understand what is the difference when it comes to the state specific exam which is there. That is why we see that in the state of UP, if you'll buy this act, they will accordingly give you in the respective bare act only, they will give you this state amendments. They'll incorporate it themselves. But if you'll download it, if you'll see some other content, then you may tend to get confused. Okay. So Section 13 है. Section 13 में भी आप देखो, it shall be lawful for the Director General come Inspector General of Police or Inspector General, Deputy Inspector General, Assistant Inspector General or of the District Superintendent, subject to the general direction of the magistrate on the application of any person showing necessity thereof to depute additional number of police officer to keep. मतलब यहाँ Section 13 में क्या था? आप अप्लाई करके एडिशनल पुलिस फोर्स किसी एरिया में अगर रिक्वायर्ड है उसके लिए आप एप्लीकेशन दे सकते हो. एडिशनल पुलिस ऑफिसर्स के लिए रिलेटेड सेक्शन था सेक्शन 13, 14, 15 और 15A भी एक हद तक रिलेटेड है. सो इफ द पर्सन कैन अप्लाई ऑल्सो एंड देन व्हेन द पर्सन हैज अप्लाइड then accordingly at his cost the application will be granted by the Director General. So it shall be lawful for the Inspector General of Police, or here in this case it will be the Director General of the Police or any Deputy Inspector General, Assistant Inspector General or District Superintendent, subject to control of which functionary? Subject to the control of the magistrate of that district, on an application that is made by the person who is showing the necessity. What is the necessity? That some additional police officers are required at any place. Then accordingly, if it is considered that the demand is proper, then such force shall be exclusively under the officers of the district superintendent, be deployed, employed, and the charge of that has to be borne by the person who has made the application. And that application can be withdrawn by 1 month prior notice. Okay, ये section 13 में था. अब additional police force in the neighborhood of the railway or other works, here also you will see that it is replaced by Director General. So whenever in this case in any railway, canal or manufacturing commercial concern, it appears to the Director General in the case of Uttar Pradesh, that the employment of additional police force is required, then with the consent of the state government, such additional force can be deployed in that area. And it will remain in force as long as the necessity is there. Okay, so this is the case for employment of additional force in the cases of neighborhood of railway, manufacturing, commercial area. Okay, in these cases, the Inspector General himself thinks that additional police force may be required. Due to which reason? The reason is because of the reasonable apprehension of the danger, reasonable apprehension due to the behavior of the people who are living there. There is reasonable apprehension that some additional force may be required. Similarly, quartering of additional police force can also be done. When the state government has made a proclamation that a particular area is disturbed or dangerous, then in that case, wherein there is a proclamation, then again we'll see that it will be lawful for the Director General in the case of UP or other officer authorized by the state government in this behalf, with the sanction of the state government, to employ any police force in addition to the ordinary fixed complement. So इस केस में जहां भी लगता है कि भाई the existing police force is not sufficient due to the disturbed and dangerous state of affairs in any particular area, then again the Director General can deploy in addition some additional police force, and it may be required to complement that the existing force which is already stationed there. So this is the quartering of that additional police force in that respective area. And the cost again then shall be borne by the inhabitants who are living in that area. So inhabitants की definition भी कभी कभी हो सकता है आपको पूछ ले explanation में कि inhabitants क्या है. Cost will be borne by the inhabitants. State government may exempt also certain inhabitants. And who will apportion as to what cost will be paid by whom? The apportionment of that cost, कि कौन कितना cost pay करेगा अगर आप liable हो किसी एरिया में जो डिस्टर्ब्ड है या डेंजरस है, वहां रिक्वायरमेंट है क्योंकि एडिशनल फोर्स जो ऑलरेडी है वहां पे वो इनसफिशिएंट है, then in that case we see that the magistrate is empowered to apportion the cost which is respectively can be placed on the inhabitants who are there of that area. Inhabitants कौन होते हैं? Include any person who themselves or by agents or servants occupy or hold land or other movable property. Inhabitants क्या है? जो land hold कर रहे हैं वहां पे, या landlords also are included within that area who are collecting rents from the tenure holder, the rayyats. So landlords भी हैं और any person who is holding the land also, they are also within the meaning of the term inhabitant. So whenever any meaning is explained in that act, then also you have to be careful. And then 15A is also there. This is the last section which is affected by somewhere second last, and the last one is section 45. So in all these sections we see wherever in the central legislation the Inspector General has been used, it has been replaced by the UP State Amendment Act of 1984, and it has been, since Director General post is there, so in all these cases it has been replaced by the expression Director General cum Inspector General. Okay. So this is about section 15 that we had covered until yesterday. Section 15 में क्या क्या हमने देखा था? Section 15 में interpretation clause देखा था. Section 15 में there shall be one police force within the general police district, and members of the police force are required to be enrolled. Section 2, superintendence of that police force in the police district lies in the state government. Administration lies in the Director General. Powers of the Director General, that is there. Then power of the Director General to make rules, section 4, 5, section 12. Then in the cases of deployment of additional police force, which is dealt under section 13, 14, 15, 15A, here also we see that the power of the Director General has been mentioned. So all these sections, these respective sections have been affected by the Amendment Act of 1984. Also, the certificate is to every police officer is given by the Director General under the seal of the Director General, and he is required to surrender the certificate when he ceases to be in the police force. Similarly, if any police officer wants to engage in any other employment under Section 10, he can take permission from the Director General. Otherwise, a police officer is duty bound not to engage in any other employment. Police officer has to take leave from the district superintendent. This is given under Section 9. And if he wants to resign, he has to give a prior 2-month notice. That is also given under Section 9. So these are certain duties. Duties also collectively we'll see, just like we are seeing these sections. So this we had covered until yesterday. And today we are moving ahead with Section 15A. In Section 15A, it is stated, Section 13, 14, and 15 we had understood. 13 deals with additional police officer employed at the cost of individual. Then we have, because application is made here under Section 13. Application आती है इंस्पेक्टर जनरल के पास, application में फिर उसके हिसाब से additional police force deploy कर दी जाती है. Section 14 में the Director General himself can deploy additional police force due to the reasonable apprehension of the behavior of the people who are there. And then quartering of additional police force also can be done when a proclamation has been there by the state government that a particular area is disturbed or dangerous. In pursuance of that proclamation, the Director General again can quarter additional police force in that area, and the cost will be borne by the inhabitants. And the magistrate is required to apportion that cost. This is given under Section 15. Then we have Section 15A, awarding of the compensation to the sufferers from misconduct of inhabitants or person interested in land. अब यहाँ पे आपको पता है ये disturbed area है, disturbed है, dangerous area है. यहाँ के inhabitants जो हैं कोई भी ऐसा एक्टिविटी कर सकते हैं जिससे कोई पर्सन जो है लॉस सफर करे. उस केस में कंपनसेशन भी दिया जा सकता है. दिस हैज बीन प्रोवाइडेड अंडर सेक्शन 15A, which has been inserted by the amending act of 1895. It was stated that in this section that if in any area in regard to which any proclamation has been notified under the last section, section 15, ये मैंने बताया था ना, स्टेट गवर्नमेंट प्रोक्लेम कर सकती है यहाँ पे. So उसी के follow through में है ये section. Any area in the respect of which a proclamation has been there, and what has happened, any person has suffered in force death, grievous hurt, or loss or damage to the property has been caused by the inhabitant of that area. Any person has suffered what? Either any person has suffered a death, either person has suffered grievous hurt, or any loss of the property. ये 3 चीज ये ध्यान रखना 15A में. ये आपको ऑप्शन में डाल के पूछ सकता है क्या क्या चीजें कवर्ड हैं. डेथ, हर्ट, लॉस ऑफ प्रॉपर्टी और कुछ और चीज ऐड कर दे. सो आपको यू हैव टू बी केयरफुल इन दैट रिगार्ड. सो इफ इन एनी एरिया which is disturbed, dangerous, with respect to which the state government has given a proclamation in which the Director General is empowered to deploy an additional force or quarter an additional police force. In that area, if suppose any person has suffered a loss of body or you can say of the property, then this loss has been caused due to what conduct? Due to the misconduct of the inhabitant of that area. Then it shall be lawful for any person being an inhabitant of such area who claims to have suffered any injury or loss from such misconduct to make within 1 month from the date of such injury or such shorter period as may be prescribed an application for the compensation. Before whom? Before the magistrate of that district. So ऐसे किसी भी एरिया में जिसके रिस्पेक्ट में प्रोक्लेमेशन इशू किया गया हो, उस एरिया में अगर कोई पर्सन डेथ, ग्रीवियस हर्ट या लॉस ऑफ प्रॉपर्टी सफर करता है ड्यू टू मिसकंडक्ट ऑफ एनी इनहैबिटेंट, so when a person has suffered such an injury, then he can make an application to the magistrate to recover the loss, and accordingly he can claim compensation as well. Okay. And in this 15A you have to remember that there is state amendment here also, that provided that the period of limitation for such application for compensation in respect of death or grievous hurt or loss or damage to the property caused before 1st day of April shall be 4 months. So 1st day of April 1939 के पहले अगर कोई डैमेज या ये हुआ है, लॉस हुआ है, इंजरी हुई है, उसके केस में स्टेट अमेंडमेंट है, ये सेंट्रल में नहीं है. इसके रिस्पेक्ट में यूपी स्टेट अमेंडमेंट इट इज देयर दैट the limitation shall be 4 months. Generally 1 month limitation is there, but with respect to any loss before 1 April 1939, then the limitation period is 4 months in state of Uttar Pradesh. Okay, so this you have to remember. Okay, what is the sole purpose of this section? The sole purpose is to give compensation to the person who has suffered any injury. Who will give? The magistrate. Okay. It shall thereupon be lawful for the magistrate of the district, with the sanction of the state government, after such inquiry as he may deem fit, and whether any additional police force has been quartered in such area under the last preceding section. So magistrate can do the following things. After making due inquiry, he can pass the following things. He can take following action. He can declare the person who has suffered the injury. He can fix the amount of compensation to such persons who have suffered the injury. And he can assess the proportion in which the same shall be paid by the inhabitants. So these actions can also be taken by the magistrate, provided that the magistrate shall not make any declaration or assessment unless he is of the opinion that such injury, or as aforesaid, has arisen from a riot or unlawful assembly within such area. Another important thing, you have suffered the loss, and when under subsection 2, the magistrate after the inquiry is going to pass any of the order for declaration, for fixing the compensation, for assessing the proportion. In these cases under subsection 2, the magistrate has to ensure himself that whenever any such claimed injury has happened, it must have resulted either from riot or from unlawful assembly. So riot हो गया, unlawful assembly हो गया, जिसकी वजह से कोई इंजरी कॉज हो गई, और इंजरी कॉज होने के बाद उसके रिस्पेक्ट में डिक्लेरेशन करना है, फिक्सिंग कंपनसेशन को फिक्स करना है, तो उसमें मजिस्ट्रेट इंश्योर किया करेगा कि क्या इस केस में जहां इंजरी कॉज हुई है वहां कोई अनलॉफुल असेंबली थी, कोई राइट हुआ था, देन ओनली द फॉलोइंग रिस्पेक्टिव ऑर्डर्स में बी passed in. Okay, it shall be lawful for the state government by order to exempt any person. Again, exemption can be made, or any class of person, from such payment of from such liability to pay the compensation. Every declaration or assessment made or order passed by the magistrate shall be subject to the revision. No civil suit shall be maintainable in respect of any injury, and so on. Inhabitants की meaning same है. So 15A हमने देख लिया. कोई भी इंजरी जब मजिस्ट्रेट देखता है राइट और अनलॉफुल असेंबली से हुई है, और उस इंजरी के लिए मजिस्ट्रेट के पास एप्लीकेशन आई है 1 महीने के अंदर. यूपी में अगर 1939 1 अप्रैल 1939 के पहले का मैटर है तो 4 मंथ का था लिमिटेशन, और इस लिमिटेशन के अंदर उसके पास एप्लीकेशन आ गई है, और इस केस में स्टेट गवर्नमेंट की सैंक्शन के साथ आफ्टर ड्यू इंक्वायरी जो मजिस्ट्रेट है वो डिक्लेरेशन पास कर सकता है कि कौन पर्सन उस एरिया में है जिन्हें इंजरी कॉज हुई है ड्यू टू सच डेंजरस कंडक्ट ऑफ द इनहैबिटेंट्स, या कंपनसेशन का अमाउंट मजिस्ट्रेट फिक्स कर सकता है, और प्रपोर्शन भी फिक्स असेस कर सकता है किस प्रपोर्शन में ये जो लायबिलिटी है ये पेएबल होगी, और सर्टेन क्लास ऑफ सेक्शन को एग्जेम्प्ट भी कर सकता है So this has been covered under section 15A. Then we have recovery of money payable under section 13, 14, 15, 15A has been done in accordance with the कोड ऑफ क्रिमिनल प्रोसीजर. यहाँ पे पुराना दिया हुआ है 1882 का, अभी तो करंटली आपका 1973 है, उसमें 441, 421 एंड 422 ऑफ द सीआरपीसी अकॉर्डिंगली लग जाता है. रिकवरी ऑफ मनी से रिलेटेड जो प्रोविजन है, सो दिस इज देयर. सो 13, 14, 15, 15A, all these sections, they deal with additional police force, generally in those areas where there is reasonable apprehension of any danger, or the inhabitants who are there in that area, they are dangerous people. Breach of peace is apprehended. And in those areas, additional police force may be deployed either upon application, or if the Inspector General, the Director General himself thinks, then also he can deploy additional police force. Or also quartering can be done. And in such area, if suppose such area is a dangerous place, and in such area some person has suffered any injury, then accordingly the magistrate can provide for compensation. He can fix, he can declare, and he can also assess the proportion in which that compensation would be payable by the inhabitants of that area. So this all has been covered under section 13, 14, 15 and 15A. You have to remember, keeping in view also the state amendments. Okay. And in 16, the same procedure with respect to the recovery of fine and also is applicable here as well. Now we come to special police officers. 17, 18, 19. स्पेशल पुलिस ऑफिसर में मैंने आपको बताया था कि कैसे ऐसा ही एक एरिया है जहां पे जो है ब्रीच ऑफ पीस या अनलॉफुल असेंबली राइट, डिस्टर्बेंस ऑफ पीस ये एप्रीहेंडेड है, और जो एग्जिस्टिंग पुलिस फोर्स है उस एरिया में इट इज इनसफिशिएंट, देन any inhabitant of that area, any resident of that area, can he be employed as a police officer? Answer is yes. These provisions have been covered under what shall then be the power of that person who has been employed as a police officer? What shall be the duty? All these answers have been provided under section 17, 18 and 19. Okay. 17 says that when it shall appear that any unlawful assembly, riot, disturbance of peace has taken place, or it is reasonably apprehended as well, and then the police force, or in this case, the police force which is ordinarily employed in that area is not sufficient, and for the protection of inhabitants, it is not sufficient, for prevention of any such disturbance in peace, the existing police force is not sufficient, for security of the property of that place, the existing police force is not sufficient. So in that area where such unlawful assembly, riot or disturbance of peace has occurred or is apprehended, it shall then be lawful for any police officer not below the rank of inspector. ये पूछेगा आपसे, कौन कर सकता है? इंस्पेक्टर से बिलो के रैंक का नहीं होना चाहिए, सब इंस्पेक्टर नहीं हो सकता है, असिस्टेंट सब इंस्पेक्टर नहीं हो सकता है, कांस्टेबल एप्लीकेशन नहीं दे सकता है, इंस्पेक्टर या उसके ऊपर के रैंक का पर्सन एप्लीकेशन दे सकता है. किस चीज का एप्लीकेशन? किसी एरिया में जहां अनलॉफुल असेंबली, रायट या ब्रीच ऑफ पीस एप्रीहेंडेड है या है, और जो एग्जिस्टिंग फोर्स है वो सफिशिएंट नहीं है इसको प्रिवेंट कर सके, then that police officer not below the rank of inspector shall make an application to whom? To the nearest magistrate, and to appoint so many residents of that area, of that neighborhood, as the police officer. Okay. Accordingly, the application shall be made for appointing, just a second, so many people in that neighborhood, and they can be appointed as police officer by the magistrate for such time and within such limit as shall be deemed necessary. So यहाँ एप्लीकेशन देता है इंस्पेक्टर और उसके ऊपर का पुलिस ऑफिसर, किसको देता है? नियरेस्ट मजिस्ट्रेट को। जैसी रिक्वायरमेंट होगी, जितने टाइम के लिए चाहिए, उतने टाइम के लिए एनी पर्सन इन दैट नेबरहुड कैन ऑल्सो बी employed as a police officer for that particular purpose. Okay. And he shall deem necessary, and the magistrate to whom such application is made shall, unless he sees cause to the contrary, comply with the application. So इस केस में अगर here shall word is used, unless there is a cause that otherwise the situation could be handled, then the magistrate may not consider the application. But if there is no such cause by which any such application should not be allowed, then definitely the magistrate has to comply with it. So this has been given under section 17, employment of special police force in any area where there is unlawful assembly, riot, or disturbance of peace, or reasonable apprehension of it. Then powers, every special police officer so appointed shall have the same power, privileges, and protection as shall be liable to perform the same duties, shall be amenable to the same penalties, and subordinate to the same authorities as the ordinary officers of the police. Then, if you have been employed as a special police officer and you have refused to perform your duties, you have neglected to perform your duties, then the penal provision is given under section 19. So 17, 18, 19 ये special police officer. उनका employment किस condition में होता है, कौन करता है, किसके application पे करता है, ये दिया है 17 में. उनकी power क्या है, उनकी duty क्या है, 18 है. और 19 में अगर वो refuse कर दें, then upon conviction before a magistrate, they may be also be held liable to pay a fine of not exceeding ₹50 for such neglect. So section 19 is the penal provision. Then yesterday we had dealt, section 20 deals with the authority of the police officer. What authority he is required to exercise? The authority which is given under the act and not otherwise. So police officers enrolled under this act shall not exercise any authority except the authority provided for a police officer under this act, and also any act which shall hereafter be passed for regulating criminal procedure. So the authority which is given under this act, and also any act which is passed for regulating the criminal procedure, which empowers such police officer, which gives such police officers any such authority. The police officer can exercise that authority. He has the power to exercise that such authority which is given to him. So this is given under section 20, general section, which deals with the authority. Then we have village police officer. Section 20 deals with authority. Section 21 deals with village police officer. Yesterday also I have explained that in many areas there were hereditary police officers. So if they have been formally enrolled, then they will be treated as police officers. They will be subjected to the authority. They will have the power. They will be subjected to the duties under the act. So this is there. Nothing in this act shall affect any hereditary or other village police officer unless such officer shall be enrolled as a police officer. So their position will not be affected unless and until they have been formally enrolled. जैसे पुलिस का एनरोलमेंट होता है वैसे विलेज पुलिस ऑफिसर है तो उसका भी एनरोलमेंट होना चाहिए. ओके, हेरिडिटरी पुलिस ऑफिसर्स का. And when they are so enrolled, they will be treated as a police officer, they will be bound by the duties, they'll have the authority which is given under the act, and so on. No hereditary or other police officer shall be enrolled without his consent and the consent of those who have the right of nomination. So with his consent he is nominated in this service. Then we have 22 and 23 also. These are also the general duties of the police officer. This we have explained yesterday also. The duty that the police officer What is the timing? He's always on duty. He cannot refuse service. That he's not on uniform, he's not in duty. Police officer is always on duty and may be employed in any part of the district. This has been covered under section 22. Then we have section 23, the general duties of the police officer. Here a multiple question can be asked within a single question, and you will have to figure out which one is correct or which one is incorrect, which one is the odd one. So for that, you have to remember certain general duties of a police officer, very important section, which is given under section 23. Firstly, to obey and execute all orders and warrants issued to him. भाई जो भी वारंट है, जो भी ऑर्डर है, जो भी सुपीरियर ऑफिसर ने ऑर्डर वारंट जो भी है, he has to obey that. He has to execute that. To collect and communicate intelligence affecting public peace. So police also plays roles for the intelligence purposes, collects the intelligence, conveys it for all those conduct which affects the public peace, and communicates also to the relevant authorities. Prevent the commission of offenses and public nuisances. Detect and bring offenders to justice, and to apprehend also the persons whom is legally authorized to apprehend. So detect and bring offenders to the justice, and also apprehend all those persons who is legally empowered to apprehend, and for whose apprehension sufficient ground exists. Then it shall also be lawful for the police officer for any of the purposes mentioned in this section without a warrant. This is one is very important. एक तो आपको पता होगा, without warrant arrest किया जा सकता है. So इस यहाँ पे अभी आगे भी आएगा एक सेक्शन, एक अदर सेक्शन या अरेस्ट तो नहीं है, लेकिन विदाउट अ वारंट द पुलिस ऑफिसर इज एम्पावर्ड टू एंटर एंड इंस्पेक्ट एनी ड्रिंकिंग शॉप, गेमिंग हाउस और अदर प्लेस ऑफ रिसोर्ट ऑफ लूज एंड disorderly character. So these are just some of the general duties. Often you have seen that gaming houses, gaming parlors which are there. Many nefarious activities are conducted under the garb of this gaming house. वहीं पे तमाम अपना जो है सारी चीज़ें चलती रहती हैं. गेमिंग हाउस हो गया, ड्रिंकिंग शॉप हो गया, मॉडल शॉप, ये सब जो खुले रहते हैं. और एनी अदर प्लेस ऑफ लूज और डिसऑर्डरली कैरेक्टर विच इज देयर. In all these places, the police officer is empowered to enter and inspect without any warrant. Apart from these, some of the general duties which are there is to obey the orders, to communicate and collect the intelligence, to apprehend the offenders, to prevent the commission of offenses, to apprehend the offenders, bring them to justice. Okay. So these are some of the important duties which have been highlighted under section 23. पुलिस ऑफिसर में ऑल्सो अगर इसका निग्लेक्ट करता है तो सेक्शन 29 लग जाता है. अभी आगे हम लोग देखेंगे. ओके. एक ड्यूटीज का मैंने यहां पे बनाया था, जस्ट अ सेकेंड. ड्यूटीज, हियर यू विल सी. ड्यूटी टू सरेंडर द सर्टिफिकेट, section 8. Duty to take leave, take 2 month advance, give 2 month advance notice in case he is resigning. So this duty is also there. He cannot withdraw from the services without any leave. Then he cannot engage in any other employment, section 10. Then the duties of the special police, that we had covered, section 18 and 19. If any person in the neighborhood, any resident which is there, that when he is appointed as a police officer, he is also bound by the duties. The authority which is given under the act, he is duty bound to act under that authority. section 20. Then village bound police. So in the village police is also bound by the duty, which is when the village police is formally enrolled, it will be treated as a police officer. Then they are also duty bound under the act. Police officer is always on duty, section 22. Then general duties we have just now covered, section 23. And then 31, another duty which is there, order to maintain peace on the public road. Maintain order on the public road. This one is also duty to maintain order on the public road, section 31. And when neglect is there of such duties, then accordingly we have section 29. Section 7 is different. Section 7 is departmental proceedings only. So this we had covered, section 23. Section 24 deals with the police officer is also entitled to lay information before the magistrate, and also he may apply accordingly after laying information for summon, warrant, search warrant, or any other legal process as may by the law be issued against any person committing an offense. So police officer is also entitled to lay information before the magistrate and apply for summon warrant. This has been given under section 24. Section 25 deals with police officers to take charge of unclaimed property and be subject to the magistrate's order of disposal. Now with respect to the unclaimed property, we have to understand that with respect to the unclaimed property, we have specific sections, section 25, 26, 27. So these sections, these three sections deals with, first of all, the duty of a police officer to take charge of an unclaimed property, and then what will happen of that property. These sections cover that. So if any unclaimed property is there, it shall be the duty of the police officer to take charge of such unclaimed property. This has been given under section 25. And when he has taken charge of any unclaimed property, कोई ऐसी property थी जिसका कोई claimant नहीं है, किसी के possession में नहीं है, पुलिस ऑफिसर उसका चार्ज ले लेगा और उसकी एक, फिर ऐसा नहीं कि लेके अपने घर चला जाएगा, उसकी एक इन्वेंट्री बनाएगा. He will furnish an inventory thereof to whom? To the magistrate of that district. And then magistrate may proceed further. He may issue a proclamation and invite any claimant who is there of that unclaimed property to claim that property. And if sufficient time elapses, then accordingly, if it is perishable, it can be sold, and the relevant money will be given to the claimant. And accordingly, if the nature is such, even after the proclamation no one has been claimed that property, then accordingly it will be sold, and the money that has been recovered, it shall be at the disposal of whom? Disposal, it shall be at the disposal of state government. So this entire thing has been covered under section 25, 26 and 27. पहला तो कोई भी है अनक्लेम प्रॉपर्टी है तो उसका चार्ज तुरंत ले लेगा पुलिस ऑफिसर और फिर उसकी इन्वेंट्री बना के मजिस्ट्रेट को दे देगा, सेक्शन 25. देन सेक्शन 26, मजिस्ट्रेट के पास आ गई प्रॉपर्टी. मजिस्ट्रेट ऑफ द डिस्ट्रिक्ट में डिटेन द प्रॉपर्टी and issue a proclamation specifying the articles which it consists and requiring any person who has a claim thereto to appear and establish his right with respect to such unclaimed property. Within what time frame? Within a period of 6 months from the date of such proclamation. पहले तो proclamation किया, फिर टाइम दिया जाता है 6 महीने का, इसके बीच में आके कोई भी अगर अपना राइट एस्टैब्लिश कर सकता है तो क्लेम कर सकता है. Then what happens? Section 27. If no person shall within that period claim that property, or if that property was perishable and has been sold in accordance with the provision of CRPC, then accordingly, if the property was not sold, it shall be sold upon the order of the magistrate. And the proceeds thereof, since the time has elapsed, the proceed thereof goes to the disposal of the state government. It shall be at the disposal of the state government. So this is the broad idea within 25, 26 and 27. Person refusing to deliver up the certificate on ceasing to be police officers. So every person having ceased to be enrolled as a police officer, he is duty bound to surrender the certificate. He is duty bound to surrender the clothing, accoutrement, appointment and other necessaries which was supplied to him. So कोई भी पर्सन जो पुलिस ऑफिसर था वो सीज कर गया, तो जो भी सर्टिफिकेट मिला था सेक्शन 8 के अकॉर्डिंग, अक्रूटमेंट, नेसेसरीज, यूनिफॉर्म, सारी चीजें ही इज रिक्वायर्ड टू रिटर्न, ही इज रिक्वायर्ड टू सरेंडर. And when he is duty bound to do that, if he refuses to do that, then section 28 is the penal provision which gets attracted. Which shall have been supplied to him for the execution of his duty, he shall be liable if he refused. If he does not deliver the thing, then upon the conviction before a magistrate, he shall be liable to a penalty not exceeding 200 rupees. And he may also be liable to imprisonment with or without hard labor, which may extend to 6 months. 6 months से ज़्यादा नहीं होगा, 200 रुपए का फाइन लग जाएगा. Okay? Or with both. So this is the penalty. When a person who was a police officer, he has ceased to be a police officer, and he refuses to deliver the certificate, he refuses to deliver any uniform, necessaries, accoutrements, and so on, which was given to him to discharge his services. Upon his seizing, he is required to return it. If he fails, then the magistrate may impose a penalty upon him not exceeding 200 rupees, or he may even be subjected to an imprisonment not exceeding 2 months. So this has been provided under section 28. Then penalty for neglect of duty. So here we see any violation of duty is there, willful breach, neglect, withdrawal from the duty without any leave, without notice of 2 months as it is required, or any breach of duty that has been mentioned under section 23. He is engaged in any employment in violating section 10. He is guilty of cowardly attitude. He has committed any personal violence upon the person which was there in his custody. Then, upon conviction before a magistrate, he shall be liable for a penalty not exceeding 3 months pay. 3 महीने की जो पेमेंट है उसकी पेनल्टी लग सकती है. Imprisonment also may extend up to 3 months. So not exceeding 3 months pay or not exceeding 3 months imprisonment. Both the things or both penalty and imprisonment may also be imposed upon him. Okay. For what? For neglect of duty, for willful breach, for neglect, or all the duties that we have seen: employment, leave, cowardly attitude, taking the permission, not withdrawal from the duty. So if he has violated any such duty, then penalty may be inflicted by the magistrate up to 3 months pay or up to 3 months imprisonment under section 29. Regulation of public assembly and procession and licensing of the same. कोई भी पब्लिक असेंबली निकालना चाह रहा है, कोई भी प्रोसेशन निकालना चाह रहा है, तो अकॉर्डिंगली परमिशन लेनी पड़ती है. डिस्ट्रिक्ट सुपरिटेंडेंट जो है उसकी, असिस्टेंट डिस्ट्रिक्ट सुपरिटेंडेंट उसकी, वो भी दे सकता है परमिशन. और अगर डिस्ट्रिक्ट सुपरिटेंडेंट या असिस्टेंट डिस्ट्रिक्ट सुपरिटेंडेंट उन्हें ये लगता है कि ब्रीच ऑफ पीस हो सकता है या कोई डेंजरस एक्टिविटी हो सकती है, then he may require that the person may take a license. When a license is given, accordingly a condition may be imposed. And when the license is given, no fee has to be taken. So these provisions have been covered under section 30. The district superintendent, assistant district superintendent may, as the occasion require, direct the conduct of all assembly. कोई भी assembly है और procession है, वो conduct कैसे करेंगी? अगर म्यूजिक बजा रही हैं तो किस लेवल तक म्यूजिक बजाएंगी, किस रूट से जाएंगी, किस टाइम पे प्रोसेशन होगा. So with respect to all these things, the district superintendent generally it monitors these things. It directs the conduct, it prescribes the routes, it prescribes the times within which any public assembly or procession can be carried down. So the district superintendent has the power of regulating this assembly and or procession. He may on being satisfied, अब यहीं पे अगर उसे लगता है अगर ऐसा कुछ गड़बड़ होने के चांस है, he may on being satisfied that it is intended by any person or class to convene or collect an assembly in such road, street, thoroughfare or to form a procession which would in the judgment of the magistrate of the district or of subdivision of the district, if uncontrolled, be likely to cause breach of peace. So यही जो प्रोसेशन है, अगर मजिस्ट्रेट को लगता है कि ये जो प्रोसेशन होने जा रहा है, जो असेंबली है, it is likely to cause the breach of peace, then by either a special notice or a general notice, he may require that the person who have been assembling or who have been conducting a procession may mandatorily apply for a license. And when the application upon such application for license has been made, on such application being made, he may issue a license specifying the name of the licensee, and also he may outlay the condition on which the assembly shall be allowed to progress, and also may defining the condition on which alone the assembly or procession is permitted to take place, otherwise giving effect to this section. And also no fee shall be charged for such grant of application. And while regulating the conduct of such assembly, while regulating the conduct of such procession, also the regulation of music may also be done. This music, how far the music can be played, by what time. So these are also covered. Sometimes in this previous year question you will see that particularly this clause has been asked. Regulation of the music, up to which extent can be controlled. Is this has been provided under which subclause of section 30? So you have to remember section 30 subclause 4. District superintendent, generally he is empowered also to regulate the conduct of any assembly or procession, and where in the opinion it appears that it may likely cause breach of peace, then mandatorily applying for a license might be required. And when the license has been applied, accordingly conditions can be imposed, and then only the assembly can be allowed to take place, or the procession can be allowed to take place. And in such conduct, the power of the district superintendent to regulate the assembly or procession is concerned, it is also empowered to regulate to what extent any music can be played on the street or thoroughfare, festivals, ceremonies. So this power is also there. Section 30. Power with regard to assembly and procession violating condition of license. So we have understood in the previous section, license can be given, and when license is given, conditions can be imposed. So any magistrate or district superintendent of police, assistant district superintendent, inspector, or officer in charge of the police station may stop any procession. So all these officers which are there, magistrate, SP, ASP, inspector, SHO, जो भी हैं, they may stop any procession which has violated the condition of the license under this section, and accordingly this power has been given under section 30A, and may order it to immediately disperse. सेक्शन 30 के अंदर लाइसेंस ले लिया था, लेकिन फिर भी अगर इन ऑफिसर को लगता है कि कोई कंडीशन वायलेट हो रही है लाइसेंस की, तो these officers may immediately order that assembly to disperse, and if they'll refuse to disperse, it will be treated as an unlawful assembly. Being a member of an unlawful assembly, आपको पता ही होगा, IPC में it is a substantive offense. So any procession or assembly which neglects or refuses to obey any order given under the last preceding subsection shall be deemed to be an unlawful assembly. Police to keep order on public road. 31. So ये मैंने आपको एक additional duty बताया था. It shall be the duty of the police officer to keep order on public road, public street, thoroughfare, ghat, landing places, and all other places of public resort, and to prevent obstruction on the occasion of assembly, public road, in public street. So this general duty is there, where on public road, ghats, public streets, and the police officer is duty bound to maintain order. अभी आपने recent एक केस देखा होगा, एक फेमस जो थे यूट्यूबर, अपना बर्थडे उनको मनाने के लिए वहां पे जो है इकट्ठा हो गए मेट्रो स्टेशन पे. So generally the police officers are duty bound to maintain order on these public spaces. Okay, it shall be the duty of the police to keep order on the public road, and so on. Disobeying or opposing any order issued by the police under this section entails punishment under section 32. So penalty for disobeying order under last 3 sections. इसमें 31 भी आ जाता है, 30A भी आ जाता है, और section 30 भी आ जाता है, regulation of public assembly. So wherever any order has been there under these 3 preceding sections, then upon conviction before the magistrate, a penalty for a fine not exceeding 200 rupees can be imposed. Okay. Every person opposing or not obeying order under last 3 section, or violating condition of any license granted by the district superintendent, or for the use of music, or for conduct of assembly and procession. So in previous तीनों सेक्शन में, चाहे ऑर्डर की बात हो, चाहे कंडक्ट ऑफ असेंबली हो, प्रोसेशन हो, कोई लाइसेंस दिया गया हो जिसके थ्रू प्रोसेशन चल रहा था, in all these cases when there has been a violation, magistrate may impose a penalty of fine not exceeding 200 rupees. This has been given under section 32. So 30 हो गया, 30A हो गया, 31 हो गया, 32 में penalty है. Then 33, saving of control of magistrate of the district. Very simple section. Nothing in this last 4 preceding section shall deem to interfere with the general control of the magistrate. ये भी जो है general power of magistrate जो है उससे interfere नहीं करता है, ये preceding sections जो थे. Punishment for certain offences on road. Very important. This is one of the penal offences that can be imposed on the general public. And here also you will remember that a person can be taken into custody without the warrant. एक तो आपने देखा था कि गेमिंग हाउस, गेमिंग पार्लर में पुलिस एंटर कर सकती है विदाउट वारंट, यहां पे कस्टडी में भी ले सकती है विदाउट वारंट. फॉर what offenses? So the categories of offenses have been mentioned. 8 categories are there. These have been mentioned under section 34. क्या है? Punishment for certain offenses on roads. Public place पे कोई offense अगर आप कर रहे हो, उसके respect में क्या है provision? Any person who on any road, open place, street, thoroughfare, limits of any town to which this section shall specifically be extended, commits any of the following offenses: to the obstruction, inconvenience, annoyance, risk, danger or damage of the residents or passengers. Obstruction हो गया, inconvenience हो गया, annoyance, risk, danger किसको? Resident या passenger को obstruction, annoyance, risk, damage, injury ये cause हो रही हो. Then कौन करेगा? Magistrate. On conviction before a magistrate, be liable to a fine नॉट एक्सीडिंग 50 रुपीज, क्या क्या पनिशमेंट दे सकते हैं? 50 रुपीज तक की फाइन मिल सकती है, और टू इम्प्रिजनमेंट विद और विदाउट हार्ड लेबर नॉट एक्सीडिंग 8 डेज, 8 दिन की इम्प्रिजनमेंट नॉट एक्सीडिंग 8 डेज अप टू 8 डेज, और फाइन नॉट एक्सीडिंग 50 रुपीज. And it shall be lawful for the police officer to take into custody without a warrant any person who within his view commits any of the following offenses. What are these offenses? Slaughtering cattle. Cattle की definition आपने देखा था. Horse भी include होता है. Curiously horse को चलाना, ये भी है. Slaughter करना, कोई भी cattle को, horned cattle हो, horse, sheep, mule, जो डेफिनेशन आपने देखी थी, एवरीथिंग इज इंक्लूडेड इन ऑन विच इज गिवन इन द इंटरप्रिटेशन क्लॉज. एनी पर्सन हु स्लॉटर्स एनी कैटल, क्लीन्स एनी कैरकस, एनी पर्सन हु राइड्स और ड्राइव्स एनी कैटल रेकलेसली, रेकलेसली हॉर्स को चला रहे हैं सड़क पे, और फ्यूरियसली, और ट्रेन्स और ब्रेक्स एनी हॉर्स और अदर कैटल, एक ऑफेंस हो गया. क्रुएल्टी टू एनिमल, ऑब्स्ट्रक्टिंग द पैसेंजर. अक्सर आपने देखा हो, आप जा रहे हो और सड़क से जो है तमाम जो है गाय भैंस आदमी खड़ा है, उसको लेके पास करा रहा है. रीजनेबल टाइम में तक है तब तो कोई दिक्कत नहीं है, लेकिन मैनी अ टाइम्स वी सी एनी पर्सन हु कीप्स एनी कैटल और कन्वेंस ऑफ एनी काइंड स्टैंडिंग लॉन्गर देन दैट इज रिक्वायर्ड फॉर लोडिंग, अनलोडिंग, टेकिंग अप, सेटिंग डाउन पैसेंजर्स, और who leaves any conveyance in such manner as to cause inconvenience or danger to the public, exposing the goods for sale, throwing dirt into the street, being found drunk, riotous, indecent exposure, neglect to protect the dangerous places. कोई कुआं है, उसके कोई बाउंड्री ही नहीं है. So in all these 8 categories we see a police officer may proceed against a person and also may arrest him without a warrant, and in these cases the magistrate may award fine not exceeding 50 rupees or imprisonment not exceeding 8 days. Jurisdiction: any charge against a police officer above the rank of constable under this act shall be inquired into and determined by an officer exercising the power of magistrate. Power to prosecute under other law not affected. So nothing contained in this act shall be constituted to prevent any person from being prosecuted under any other law, provided double jeopardy shall not happen. So this has been covered under section 36. Recovery of penalty and fine imposed by the magistrate. So recovery of penalty and fine that has been imposed by the magistrate, in such recoveries accordingly the provisions of section 421 to 424 of the न्यू कोड ऑफ क्रिमिनल प्रोसीजर, 1882 है अभी, अकॉर्डिंगली करंट कोड के हिसाब से these provisions will be applicable. Then 38, 39, 40, 41 has been repealed. 42 deals with limitations of action. All action that has been there, all prosecutions that has been there, the general limit for taking an action, this has been provided under section 42, limitation for action. कोई भी एक्शन लेना है, कोई कंडक्ट हुआ, उसके बाद कोई एक्शन लेना है, तो उसका जो लिमिटेशन पीरियड है, इट शैल बी विद इन 3 months आफ्टर द एक्ट कंप्लेन्ड ऑफ शैल हैव बीन कमिटेड एंड नॉट अदरवाइज. तो 3 महीने की लिमिटेशन लगी हुई है सेक्शन 42 में. एंड नोटिस इन राइटिंग ऑफ सच एक्शन एंड ऑफ कॉज देयर ऑफ शैल बी गिवन टू द डिफेंडेंट और टू द डिस्ट्रिक्ट सुपरिटेंडेंट. और नोटिस जो है डिफेंडेंट को दी जाएगी, पुलिस ऑफिसर के खिलाफ है तो डिस्ट्रिक्ट सुपरिटेंडेंट, असिस्टेंट डिस्ट्रिक्ट सुपरिटेंडेंट को भी दी जाती है. नोटिस कब तक दी जाएगी? उसका है 1 month एटलीस्ट बिफोर द कमेंसमेंट ऑफ एक्शन. एक्शन लेने के 1 महीने पहले तक नोटिस आ जानी चाहिए. और एक्ट कंप्लेंट है, उसके 3 महीने के पहले एक्शन शुरू हो जाना चाहिए. सो दिस लिमिट इज जनरली प्रोवाइडेड अंडर सेक्शन 42. ओके, टेंडर ऑफ अमेंड्स है ये सब. Plea that the act was done under warrant. So police officer, whenever any action has been brought against police officer, the police officer is entitled to take the defense that whatever act that has been complained was done under any warrant that was issued by the magistrate. And how this has to be proved, this also you have to remove. This can be proved that the action has been done under a warrant by production of that warrant. So by producing the warrant directing the act, the magistrate and the defendant shall thereupon be entitled to a decree on his favor. So this plea the police officer is entitled to take. It shall be lawful for him to plead that any act that has been complained of was done by him under authority of a warrant issued by a magistrate. And he is required to produce the warrant, and then accordingly the decree can be drawn in his favor. Provided always that any remedy which the party may have against the authority issuing such warrant shall not be affected by anything contained in this section. Remedy is not affected. Police officer to keep diary. This is also very important section. Here you have to remember that this is the general diary. Case diary is different under 172 of CRPC. So the police officer in charge of the station is required to keep a general diary, and this has been maintained under section 44. इसमें क्या record होगा? It shall record all the complaint, all the charges that has been preferred, name of the person that has been arrested, name of the complainants which are there, offences that has been charged, weapons or property that have been taken, and names of the witnesses that have been examined. All these are required to be mentioned in a general diary which is mandated under section 44. So police officer जो है एक डायरी भी मेंटेन करता है जो सेक्शन 44 मैंडेट करता है. स्टेट गवर्नमेंट में प्रिस्क्राइब द फॉर्म ऑफ रिटर्न. रिटर्न फाइल करता है कौन? डायरेक्टर जनरल. सेक्शन 45 में मैंडेटेड है. स्टेट गवर्नमेंट में डायरेक्ट द सबमिशन ऑफ सच रिटर्न दैट हैज टू बी फाइल्ड बाय द, यहाँ इंस्पेक्टर जनरल है, डायरेक्टर जनरल कम इंस्पेक्टर जनरल and other police officer, as such the state government shall seem proper. Then scope of the act we had dealt. It shall not by its own operation apply, rather a notification in the official gazette has to be issued extending the act in the relevant district, general police district. Okay. And then accordingly the rule making power has been given to the state government for regulating the procedure, time, manner, condition, and for implementing the general provisions of the act. And then the last section of this act deals with authority of the district superintendent of police over village police. So it shall be the lawful for the state government in carrying this act into effect in any other part of the territory subject to such state government to declare that any authority which now is or may be exercised by the magistrate of the district over any village watchman or other village. So the general authority of the district superintendent over village police, that also the state government can accordingly make provision. This has been given under section 47, not so much important. So this is all about the Police Act. Meanwhile, 3 important UP state amendments that you have to remember. You can note down the sections, or if you have the amended version according to the UP specific exams, then also you will find 3 important other sections: 32A, 32B, and 34A. Apart from these, if you are able to figure out any copy of the Bare Act that is available on the internet, then you will get these sections which are highlighted over here. Specifically, 3 more sections are there which are specific to the state of UP. And in the previous lecture, we discussed those things. With respect to the state of UP, what is the situation that has been given under, provided in the today's lecture. Slightly modification with respect to the powers of the Inspector General is there. Here, the word Director General cum Inspector General is used. Apart from that, 32A, 32B, and 34A. These are also state-specific amendments. 32A deals with the power to prohibit mass drill or mass training. कौन कर सकता है? मैजिस्ट्रेट. कोई भी मास ड्रिल है, मास ट्रेनिंग हो रही है, उसके रिस्पेक्ट में प्रोहिबिशन की पावर किसको दी गई है? मैजिस्ट्रेट को दी गई है. Magistrate of the district, when he considers it necessary to do so for the preservation of public peace. And in such preservation, he may order the prohibition of any such mass drill which is there, mass training which is there within his jurisdiction, or the carrying of any arms. अब आर्म्स का मतलब क्या है? सो सेक्शन 32A क्या कहता है? भाई कोई कैरिंग ऑफ आर्म्स है, कोई मास ड्रिल हो रही है, कोई भी ऐसा ट्रेनिंग हो रही है जिसमें कई लोग इन्वॉल्व हैं, तो मजिस्ट्रेट जो है उस डायरेक्शन का ऑर्डर पास कर सकता है उसको प्रोहिबिट करने के लिए। आर्म्स की डेफिनेशन में क्या आता है ये भी पूछ सकता है कि व्हाट इज कवर्ड अंडर द डेफिनेशन ऑफ आर्म्स एज इट इज गिवन अंडर सेक्शन 32A। आर्म्स में एनी टाइप ऑफ ऑफेंसिव वेपन, एंड इट इंक्लूड्स लाठी, डंडा, स्टिक एंड बेलचा। ये आपको 32A में मिल जाएगा। लाठी, स्टिक, डंडा, बेलचा, any offensive weapon is included within the definition of arms. So when several people are there with arms, they are conducting a mass drill, they are conducting a mass procession, and in the given situation the magistrate considered necessary, he may pass an order prohibiting such mass drill, mass training, or mass carrying of arms. And this prohibition, what is the duration until which it will remain in force? These prohibition that can be passed by the magistrate, it shall not remain in force for a period more than 3 months. 3 महीने तक ऐसी ड्यूरेशन, ऐसी जो ऑर्डर है वो इनफोर्स में रहेगा। ये आप ध्यान में रखना, ओके, जनरली। And provided that if the state government considers is necessary, it may be extended to period not exceeding 6 months. So this is the general provision for prohibiting the mass drill training. And if any person has contravened any order or direction passed by the magistrate, generally it stays there for 3 months, it can be extended to 6 months. And if any person violates such direction which has been passed, which prohibits such mass drill, mass training, carrying of arms, then section 32B provides punishment for that. It may extend to 6 months, or fine which may extend to 2,000 rupees, or with both. So this is 32A and 32B. 34A deals with compounding of offences under section 32 and 34. So these 3 important state amendment space specific insertions which are there that you have to remember. So यूपी पुलिस एक्ट में आपको जो है ध्यान रखना है सेक्शंस क्या क्या थे। 32 में आगे यहाँ पे स्टेट स्पेसिफिक आ जाएगा 32A, 32B, और यहाँ 34A भी आ जाएगा, compounding of offences वाला. Apart from that, mostly everything is sorted. Okay, I hope you're able to score full marks whatever question is asked in the UP Police Act 1861, the Police Act 1861. Okay, then after that we have to do regulations also. Some of the sections, some of the important questions we'll see. Tomorrow we'll also discuss some of the important questions from the UP Police Act, and then you'll also be having the test series, so you'll have an idea of what kind of questions they are going to ask. So this is all about the the Police Act of 1861. Some of the broad sections which are there in the act, we have tried to highlight it and make it easy for you to comprehend and then remember. Maybe if you'll watch the lecture 1 or 2 more times, then you'll be able to, and then after already you must try to recall it, you must try to remember these sections which are there. So with practice, you'll develop this. It's not so much difficult. That's all for today, guys. Okay.